Okay, good morning, everyone. Thank you for your time to join this session. I know today is a public holiday, and then some of you all might quite be stressed out because, as what we all know, the exam is coming soon and around the corner. So, also, this is to cover the previous session, which I didn't do a very good explanation of what is an appeal. And for everyone, so if you all don't understand on anything, you may post your comment in the chat group so that I will explain accordingly. And throughout the session, I think this is for the last two chapters, which is appeal and also the state of execution. Can I have everyone to get ready with your rules of court with you? So later when I use the rules of court, then everyone will be easier to go through. After these two chapters, I will be guiding you all for the past year question. Is that okay for everyone? Okay, now we come to the appeal chapter. So in the appeal, I will be guiding you all what is an appeal. I will be explaining what is an appeal and which courts do have the jurisdiction and the applicable principle and the procedures that has to be followed lah. So let's start with the High Court first. Never mind, we start from the introduction first. So appeal is a rehearing based on the judgment given by the court. And what we have studied in the criminal proceeding is that in the case of Ang Jin Lee, the court held that an appeal must be a final matter and the party's right has been disposed. So we cannot simply say that, oh, I want to appeal, but the matter is not finalized yet. So you must make sure that at the end of the trial, the judgment has been given, and now either party is not satisfied with the final judgment. And this is how does an appeal arises. And also, the matters also can be either appeal as of right or with the leave of the Court of Appeal. So under the two-tier system of appeal in Malaysia, we have first one which is from the sub-court to the High Court, then from High Court to Court of Appeal. And then the second type is from High Court to Court of Appeal, and then the Court of Appeal to Federal Court. Now, from sub-court to the High Court, right, the right of appeal is under Courts of Judicature Act 1964. So the latest slide, I will show it as CJA 1964. So under Section 27, the High Court can hear the appeal from sub-courts. And furthermore, in Section 28, no appeal is allowed if the subject matter is below or less than 10,000 ringgit Malaysia, except for the maintenance of wife and children. Does anyone have any question on this? Okay, now we come to the next, which is filing of notice of appeal. A notice of appeal simply means it is an entry of appeal. So if you want to enter for an appeal to the High Court under Order 55 and Rule 2, the notice of appeal must be given within 14 days from the date of decision. Let's say today is 17th of June. So if your judgment is given on today, within the 14 days, you must file a notice of appeal from the sub-court to the High Court. And now we come to the procedures. So the governing procedure is under Order 55 and Rule 3. So the first one is Sub 1. Notice of appeal shall be informed 111 and filed in the court that being appealed. Which means that if your appeal is appealing against the decision from the magistrate or the sessions court, you must file the notice of appeal to that particular court. And sub 2 says that the notice of appeal shall state whether whole or partial of the judgment is being challenged. Because the thing is, you are not necessarily to appeal against the entire judgment. It could be partially, maybe just one or two decisions given by the court. So that in your notice of appeal, you must state it whether you are appealing against the whole or partial of the judgment. And then sub 3 states that the duplicate of the notice of appeal must be served within the limited time frame. So, okay, I see one question here. How about the decision is an oral judgment, not the written judgment? Let me check for a while first. The oral judgment, which means that it's a direction or what? It's just an oral decision. Let me go and flip my rules of court now. Maybe think, because I saw the definition in Order 55 Rule 1, right? Includes judgment, order, and decree. So the order includes the direction also, right? So it falls within the scope. Okay, so actually, okay, so where was I again? Okay, so sub 4, the appellant shall apply to the courts for notes of proceedings and ground of judgment while filing for the appeal. So before I go further, does anyone don't know what is a note of proceeding? Okay, so a note of proceeding simply means that there is a transcribing from a court's recording, because throughout the trial, everything is being recorded. So that let's say we have for today, we have a 2 hours trial. So that after the recording is available, the transcriber is either by the law firm or they hire somebody to do that. So the transcriber has to transcribe every single word by word, not summarize, which means that, let's say this is the first witness, what are the things that he said, you must transcribe it out exactly. And it's very, very time consuming. Imagine that within 1 minute, how many words we have said, and somehow we cannot assure whether the words are really, really clear or the recordings are in good quality. So that average 1 hour recording, you have to spend about 4 to 5 hours to transcribe the recording, because after the transcription is available, you have to file to the court, and it is for the record of the court. And so if let's say later on notes of evidence and notes of proceeding, whether or not it's the same, I will check for you. I will check for you later. I will jot it down and then I will check for you. But because I also have to clarify first. Yeah. So the note of proceeding is simply like this. It's just a dialogue between the parties, and then everything has to be transcribed out words by words. Okay. So the grounds of judgment sometimes may not be that soon or efficient to be available from the judge lah. So after you file the submission, you are given some time to file your note of proceedings. Then after that, you will only be available to get your full and final judgment. Is that okay for everyone? Okay, we come to the next part. Record of appeal. The record of appeal is for the purpose of appeal against a decision made after the trial. And then under 55 Rule 4, Sub 1, it shall be filed within 1 month from the date of filing of notice of appeal. So for everyone's information, when you see the wording shall is there, which means that it is more higher, the threshold is much more higher than the word must. Because most of the time when you see the parties application is not given on okay, Ting, for this part, right? I will go and check it later. Then I will respond to you and Kevin. Okay, so for the record of appeal, right? The shall is much more higher than must, which means that you have to comply it with strictly. Okay, so most of the time when you see the why is parties application is not given because they didn't comply with the rules containing the wording shall. Okay, and then you will see the items from A to H is available under Order 55 Rule 4, which are the documents lah. So you will see some of the examples like the pleadings, the ground of judgment, memorandum of appeal, the decision, order of judgment. So these are the items from A to H. But throughout your exam, right, you have to see how much does the mark allocated for that question. Then you will only see how many details you have to put in. So if let's say the question is about 5 marks, you just and it's all about the record of appeal, maybe you can write some of the examples from A to H lah, because you also have to make sure that your sub 2, sub 3, and sub 4 is included in your answer. So the sub 2 is not of evidence of ground, found as a supplementary record of appeal without leave of court, if not ready at the time of filing. So which simply means if your grounds of judgment or the note of evidence is not available at the time when you file the record of appeal, you may file it subsequently. Then sub 3 says, memorandum of appeal shall be in this form and then shall state concisely under the distinct head, which means that you have to follow the entitlement accordingly. So the entitlement is I try to see whether I can find an example for you or not. But because this is the court of appeal, and then most of the time when you draft the statement of claim, you will write down in the sessions court of which one, but this one is just the same logic that you have to follow the entitlement precisely. And then sub 4, draft the index of document in the record of appeal shall be sent by the solicitor and opponent counsel may object within 48 hours. So that in your record of appeal, you have to draft, yeah, you have to include an index lah, like what you are going to be included in the record of appeal, and then the opponent counsel, of course, they will object, but the time frame is within 48 hours. Is everyone okay for this part? Okay. Now we come to notice of appeal against any decision made after the trial. So it is given under Order 55, Rule 5 of the Rules of Court. The example is interlocutory applications in sub-courts. So for the interlocutory applications, right, actually these are the interlocutory applications simply means that your application requires the interference of the court. Like whatever application you have to put it, like those the very good example is Order 32 Rule 1. Notice of application supported by affidavit. That is one of the interlocutory applications. So if you are going to appeal against the decision for this one, yes, it falls under Order 55, Rule 5. And then sub 1 says that it shall lie to a judge in the chambers of the High Court, which means that everything is done in the chambers, not an open court. And then sub 2 says the notice of appeal in Form 11A shall be found in the registry of the court, whether it's magistrate or sessions court, within 14 days. I'm so sorry, this is a typo. From the date of decision. And sub 3 says that the appellant shall file notice of appeal within 1 month to the High Court containing the items from A to D. So we see what is A to D. First thing is law of evidence, ground of decision, the decision of the statutory body, or the documentary exhibits. So last but not least, the logics are the same. So the list of appeal under 55 Rule 6 says that the registrar shall enter the appeal in the list of appeal from the sub-courts upon receiving the notice of appeal. That means the sessions court registrar has to stand by, because this case is going to appeal to the High Court already. So is everyone clear on this? Okay, now we come to the fresh evidence. The fresh evidence, I'm pretty sure that in your criminal procedure, right? I think this one was not included because this is a common law case, Parks, so that logics are the same. The requirements for you to tender a fresh evidence is it was not available during the trial and credible, and it could influence the decision of the appeal. The reason why why particularly are not available during the trial is because res judicata, which means that the court has given the judgment based on this particular evidence. If you are going to tender it again, sorry, my friend, you are caught by the rules of res judicata. Okay? And now we come to the notice of cross appeal. The notice of cross appeal is by another part, is the opposing party who is trying to vary the decision that being appealed by the appellant. So the respondent may file a notice of cross appeal within 14 days and serve it to the appellant the duplicate notice in Form 113, which means that now I already filed my notice of appeal. And now the opposing party definitely, who is the respondent, definitely wouldn't stand by there and say, so what, you appeal. They will going to file a notice of cross appeal to vary it. Is everyone okay? Okay, now we come to appeal to the High Court under the written law. This is governed under Order 55A. And Rule 1 Sub 1 says that the right of appeal is the decision made by person or body of persons, which means that this is from the tribunal. For example, housing tribunal, consumer tribunals, because these are not a body formed in the way of court. So that means the tribunals simply means that you can go there without hiring a lawyer. So that if you are dissatisfied with the judgment given by the tribunal, you can appeal to the High Court under this Order 55A. So the procedure is you file an originating summons plus affidavit in support. So the documents to be annexed are given under 50A sub 2 A to D, and the contents are almost the same lah. Industrial court very good question. Okay, Ting, let me get back to you after this, and then because I have to check whether the industrial court is fall under this one or not. Okay, so the hearing is in the open court, and then nonetheless, the fresh evidence is still under this one. Order 55 Rule 7 plus your case led at Marshall. And further appeal is to the Court of Appeal already. Is given under Section 67 sub 1 of your CJA. So whether the non-compliance will result that the appeal is fatal, this is given in the case of Mat Yassin bin Dollah. The court held that appeal is fatal because of non-compliance. You see, fail to include a copy of decision in the record of appeal. So what we have seen in the record of appeal is that you must include your record of appeal. You see, Order 55 Rule 4, right, shall contain the copies of the items. So the wording shall. Now I'm going to tell you all the importance again. When you see the wording shall, and if the question asking the non-compliance of the party, so you can quote the particular rules and says that the appeal can be the procedure can be challenged because of the non-compliance, and you just write the particular order out. Is that okay? Okay. Now we come to appeal from the Registrar of High Court to the judge in chambers. So basically, you might see the High Court consists of the judge or the registrar, so or the other officers. So now the decision I want to because the thing I want to differentiate it, because sometimes your application is being rejected not by the judge, could be the registrar. So if you are dissatisfied because of the decision is given by the registrar, you can appeal to the judge in chambers under Order 56. So under Order 56 Rule 1 sub 1, the right of appeal says that is based on the judgment or the decision of the registrar of the High Court. For your example, it's a decision of a summary judgment. So under Rule 1 sub 2, the procedure is you serve the appellant has to serve a notice in Form 114 on every party. And then sub 3 further states that the notice must be issued within 14 days after the date of decision and served to the parties not less than 5 days before the hearing. And the hearing will be before a judge in chambers, not in an open court. Is everyone okay? Now, after we already covered the area in the High Court, right? Now we come to Court of Appeal. Now, under under your Article 121 something, right? Of your federal constitution, it says that the Court of Appeal can hear the appeal from the High Court or from the sub-court because the appellate jurisdiction. Similarly, in Section 67 sub 1 of your CJA, the Court of Appeal has the appellate jurisdiction to hear the appeal. Now, you under 68 of your CJA, the matters to be appealed are categorized into you are going to appeal the matter as of right or with the leave of court. So, under the category of appeal as of right, under Section 68 sub 1 and sub A, if your amount being claimed is more than or at 250,000 or the judgment of interpleader after the full trial, this is given under Section 68 sub 3. However, if the amount is less than 250,000 or the judgment is on the cause only or the summary judgment of interpleader, you have to apply for the leave of court to appeal the matter. And there is no appeal if it is on the consent judgment or the judgment of High Court is declared as final in any written law. The consent judgment, as we already know, the consent judgment is before the judgment is given, both of you already enter into a settlement, like this is what I can accept and this is what the other parties can accept. So we enter a consent judgment in a way of contract, and this is the reason why you cannot appeal further because both parties has agreed. Unless the consent judgment can be challenged when it is misread, fraud, mistake, so the exceptions in the contract law applies. So at the end of the day, since we have already discussed some of the matters being appealed is required to accompany with the leave of court. So if the leave is not granted, then the matter cannot be appealed further and it is the end of the matter. This is given in the case of Lam Kong Court Limited. Is anyone okay? Or possible new evidence being adduced for appeal? Yes. Because the appeal is a rehearing, so that when you include because when you appeal, right, the reason why you appeal, the reason why the appellant appeal is because first thing, he is not satisfied. How does he not satisfied? Maybe he has a fresh evidence that not available at the court at the time of the trial. So he discovered it subsequently, and then he or she wishes to tender it during the appeal stage. It could be. Is that okay? Now, however, pursuant to the practice direction, there might be certain matters appealable as of right. First thing, certiorari right. So for I think as a fresher, I'm not sure whether you all have come through this. What is a certiorari right? The certiorari right simply means that the order to quash or nullify the decision of a public body. I'm going to give you all a very, very, very clear, a very recent example. If you all still remember the Ahmad Zahid's acquittal, right? Malaysian Bar has filed a judicial review to the High Court because the first to the Court of Appeal lah. Because the first thing is, although Article of 145 sub 3 of your Federal Constitution and also Section 376 of your Criminal Procedure Code states that the powers of a public prosecutor is to initiate, discontinue, or transfer the criminal proceeding. But the thing they are using, but the grounds relied by the Malaysian Bar is that they must exercise their right or discretion appropriately. So therefore, the part of their relief is certiorari, which means that they want the appellate court to quash the decision given by the High Court and reinstate the prosecution against Ahmad Zahid. This is so-called a certiorari. And now declaration is different from that because certiorari is within the scope of a judgment, but declaration could be a document. Is that okay? Like, let's say I'm telling you, let's say now today, the court is telling you, oh, this report is invalid. So this is a so-called declaration now. But injunction, I guess I no need to further elaborate as we have covered it quite thoroughly. And then another matter is petition for winding up and bankruptcy. Third one is matters related to Law Reform Act, which means your divorce or anything, you have to appeal. And the judgment of unliquidated damages. These are the matters can be appealed as of right without any leave of court of appeal. Now, we are coming to entry of appeal under the RCA. So under RCA Rule 17, entry of appeal to Court of Appeal is by filing 4 copies of Notice of Appeal in Form 1 to the in the registry of the High Court, which means that you have to serve 4 copies to the High Court registrar. And then the appellant must send a copy of Notice of Appeal by registered post to the Court of Appeal. So the registered post to be very precisely in your Order 10 Rule 1, the manner of service of a writ is by way of prepaid AR registered post. And this one is a registered post. So that to differentiate between these two, registered post is a red color sticker, and then you just need to insert the details and then you can trace it from the Post Malaysia website, like how you trace the shipment of your delivery. But the prepaid AR registered post, that comes with a yellow card, and then it will indicate who has received the document. So it will return it back to you to file your affidavit. If let's say you want to apply for the substituted service, but registered post, it wouldn't come back. You just need to monitor the delivery status online, that's all. So under RCA, the Notice of Appeal is the thing is Rule 12, you must be made within 30 days. If you're in the case where no leave is required, then for Rule 6, the service of Notice of Appeal is on all parties within 30 days after filing. After the filing. So Rule 27 says that the extension of time is by filing motion supported by affidavit with the leave of court and shall be heard in the open court. So since we are coming to the Court of Appeal already, we are not dealing with any notice of application. It's all done by motion. So motion supported by affidavit, and the extension of time will be heard in the open court. So I will give you one case that So Keng Hian. Actually, this case is mother of case for every single extension of time, whether you are in Court of Appeal, Federal Court, or High Court, Sub-Courts. This can be used because the factors considered by the court to grant the extension of time. First thing is the length of delay. The reason, second one is the reason of delay. And then third one is the chance of success. Fourth one is whether the other party is prejudiced. So if let's say you are not sure about the third one, you can use length or reason of delay, and then whether the other party is prejudiced. So because we have to make sure that the court will not simply grant an order or allow an application if other party is being prejudiced. So this is the case that you have to use that. Now we come to another stage. If the leave of Court of Appeal is required, then how are you going to apply for leave? This is given under Rule 28A of your Rules of Court of Appeal. So sub 1 says is by way of motion supported by affidavit and filed with the registrar. Then sub 2 says the matter shall, sorry, it's mother of case right now. Okay. Sorry. So the sub 2 says the matters shall be contained in the affidavit. First thing, which court the matter is originated. So let's say your matter is from magistrate, you have to say it, or etc. etc. And then the brief description of the action or the proceeding, which means that you have to tell the court this case is concerning on what matter. And then the date and brief description of the order made by the court of first instance or from which court. So you have to tell that, this is the order given by the court at the first instance, like explaining what are the judgments and this and that, and then brief statement of the grounds to seek for an appeal, which means your relief lah. So sub 4, when the leave is granted, the appellant shall file the notice of appeal within 14 days and the record of appeal within 90 days at the registry. And if the leave is refused, again, the appellant cannot appeal further, and it is the end of the matter, as per the case of Lam Kong. Is everyone clear? Okay, the notice of cross appeal actually during this appeal, right, I would say if you manage to understand the court issue like record of appeal, notice of appeal, and then the notice of cross appeal, right, actually logic is the same to every single court. Just that the particular rules and the sections might be slightly different. You see, as we can see, the purpose of the notice of cross appeal is the respondent to vary part of the decision within 10 days after the notice of appeal is being served. So the reason why I put this case Kabushiki. In this case, the respondent intended to reverse the whole judgment. So the court held that if you are going to reverse the whole judgment, you shouldn't file the notice of cross appeal because it is limited to the part of the decision. Since your intention is to file is to challenge against the whole decision, might as well you just file a notice of appeal. Is everyone okay? Okay, the stay of execution in the Court of Appeal is given under Section 73 of your CJA. So I think everyone also have studied this, no matter in your criminal procedure. as a general rule, an appeal does not operate as a stay of execution, and the purpose of the stay of execution is for you to temporarily suspend the execution of judgment. And in CPC, if I'm not mistaken, it's section 311, if you are going to apply for stay of execution. So now we come to the stage of, okay. Okay, I see a question here for the notice of cross appeal. Same case can be used from sub-court to high court, court of appeal, and this one, when the logic is the same, why not? Because you see, led against Marshall, you can use it in the appeal in high court, you can use it in the appeal in the court of appeal, and also in federal court. So if your whole purpose is served there, you can use that, as long as the logic or the principles are still the same. Is that okay? Okay, now we see the following of memorandum and the record of appeal in court of appeal. This is given under Rule 18. The memorandum of appeal is to specify the point of law or fact that the lower court has wrongly decided, and you have to itemize it accordingly. Okay. Simply means in your memorandum of appeal, you are going to tell the appellate court judge it was a wrong decision given by the previous learned judge. And then it is in the sense of you are criticizing the judge. I will show you this in the sample of memorandum in the next slide. But now we come to the record of appeal first. The record of appeal is the bundle of documents to be included as supporting documents. This is the first one. Second one is memorandum of appeal. Third one, notice of appeal, and then your judgment and notice of evidence, ground of judgment, and pleadings. So the memorandum of appeal has to be filed and the record of appeal has to be filed within 90 days from the date of the decision is given. When the leave is not required, or when the leave of COA is granted, which means that that 90 days calculation is based on whether there is a need of leave of court of appeal. If yes, then you further extend the 90 days because we also don't know how long does the leave granted. And then you have to serve the memorandum and the record of appeal to all parties within 6 weeks. So basically, if you have seen those law firms handle the court of appeal matters, you will see the bundles are quite voluminous because everything has to be in a very thick bundle. And last time, I think I remember I've handled my previous boss to handle one case for the court of appeal. So because everything has to be filed in 40K, it's very, very voluminous, and a normal dispatch boy will not be able to deliver everything to the court of appeal. So that we have to hire someone to drive and deliver the document by using a van. It's very voluminous. And then nonetheless, your extension of time is still governed under Rule 27. And then the case is Saw King Hian. Now I'm going to show you all the sample of memorandum of appeal. So in your memorandum of appeal, you see the appellant's appeal to the court of appeal against the whole decision of the judge this name, who given on the 13th day of this day, and the following ground, because you see the first one, the learned judge erred in law and in fact in dismissing this one. That means you are criticizing, you say you are going to criticize the fact finding by the previous judge. Now we come to hearing of appeal. So as we know that, as I have already explained, an appeal is a rehearing. Therefore, the COA will have the same power when we are talking about the appellant jurisdiction is same as the High Court. In the case of Tan Jin Wo, sorry, in the case of Tan Jin Wo, the court held that an appeal is a rehearing and the appellate court will less likely to interfere the fact finding by the previous court. So I think this one you also have covered in your criminal procedure. And then the case is Chia Han Kiet. The general rule for the appellate court will not interfere the fact finding. The reason why they say it so is because, first thing, appeal is just a rehearing. It doesn't involve the examination of witness, and it's based on everything is just a rehearing. That means it's based on the submission by each party, so that the appellate court will not be able to examine everything as like the previous judge like the appellate court judge will not be able to examine the demeanor of the witness or how does the case conducted. So that is the reason why the appellate court will less likely to interfere the fact finding. Is that okay for everyone? Okay, now we come to the absence of the party. Now, this is given under Rule 23 of your RCA. If the appellant is absent, then the appeal may be dismissed, but the appellant may apply for a rehearing, and nonetheless, you have to tell the reason. But if the respondent is absent on the day of appeal, unfortunately, the appeal may proceed. Now, you see, in section 69 of your CJA, the Court of Appeal has the discretion whether or not to allow fresh evidence by oral evidence. Because the thing is, your evidence if you are going to tender a fresh evidence, right, is up to the court's discretion. And whether there is a leave required, you see, if your fresh evidence is based on interlocutory appeal or the matters occur after the decision is appealed, yes, you can apply for fresh evidence as of right. But when your matter is after the trial and the leave of Court of Appeal is granted and special grounds are shown, you are required to apply for the leave by the Court of Appeal to tender a fresh evidence. Nonetheless, it is still go back to the case of Lett and Marshall with the principles. Is everyone okay? Now we come to the fresh point of fact or law. Generally, the fresh point of fact or law is not allowed to be raised during the appeal. However, there are certain exceptions. First thing is interest of justice. This is given in the case of luggage distributors. And this one, the luggage distributors, if I'm not mistaken, is regarding the removal of private caveat, right? Because there are three principles there. First thing is whether the person has a caveatable interest. Then the next one is the serious question to be tried. And then third one is the balance of inconvenience, so that the interest of justice is based on, in this case, if I assume it correctly. And then the second exception is solely on point of law and fact without introducing evidence. This is the case, one thing. Third one is ex face illegality. So this is a Latin term, says that illegality on the face. So you see the case, the appellant filed an appeal and raised the point that the documents was ex face illegality. However, the court subsequently dismissed the appeal with cause it was not decided in the trial, and raising it in the appeal it shows a mere afterthought lah. So this is the reason, so this is the case that you can reuse, because I know this is quite contradicting, but when you want to see whether the ex face illegality is properly being applied, you can use this case. Now, it come back to this, whether the Court of Appeal may interfere the finding of the High Court general rule, reluctant to interfere. Similarly, Chia Han Cat's case in your criminal procedure, but this one, since it's a civil case, is Sundram. And then the exception, fact is inconsistent with the evidence given, evidence is inadequate to support the fact, relevant evidence is not considered, misapprehension of fact by the judge. And then, if I'm not mistaken, in criminal procedure, right, there are 8 exceptions. Similarly here, there are more than these 4, but I just simply take 4 out of it, because if I include it too comprehensively, I'm also afraid that the timeline is quite tight, and then you all might not be able to memorize all. That's why I picked the 4 simple one. And now we come to the powers of Court of Appeal to make the orders. So similarly, allow the appeal, dismiss the appeal, vary the decision, or order a retrial. Same as what you have studied in your criminal procedure lah. Is everyone okay as of now? Okay, now we come to the final one, which is appeal from Court of Appeal to Federal Court. Section 96 of your CJS states that appeal to Federal Court is required with leave of court granted under Section 97, which is for the judgment given by the Court of Appeal, decision as to the effect of Constitution, including the validity of written law. So to guide you all further, usually Federal Court are dealing with those matters related to states or constitution. So very less likely your case can go to the stage of Court of Appeal unless Federal Court, unless it's very, very serious and the Federal Court has granted you the leave lah. So the application for leave is given under Rules of Federal Court 1995. In Rules of Court of Appeal is RCA 1994. However, in Federal Court is given under RFC 1995. So under Rule 105 of your RFC, the application for leave is ex parte motion supported by affidavit. And if the Federal Court refuses to grant the leave, it is the end of the matter. Same as what we have learned Lam Kong Court. And we come to the matter appealable under the RFC, the CJA. Costco container lines says that the cause of matter decided by the High Court in exercising the original jurisdiction and is against the decision of the Court of Appeal. And the question must involve question of law of general principle and good prospect of success in the appeal. So that if you want to appeal to the Federal Court, you must make sure that these 4 principles are satisfied. Is that okay? Okay, now we come to the entry of appeal. In the notice of appeal governed under RFC 1995, under Rule 47, it must be made within 30 days if no leave is required, or 14 days if leave is required. But I would rather say most of the time leave is required, as what I've done my research on the online. Most of the time when you want to appeal to federal court, leave is required. So the notice of appeal shall substantially be informed and shall state whether whole part or partially of the judgment is being complained. And then now the filing of notice of appeal under RFC, 6 copies under Rule 56. 6 copies of notice of appeal to be filed in the registrar of the Court of Appeal, and 1 copy in the registry of the Federal Court. So it is also the same. You have to file more than 4 copies. You also have to file a voluminous copy in Court of Appeal, 4 copies. In Federal Court, 6 copies, and 1 to the registry of the Federal Court. And 56(1)(a) says the court may order for security for cost by respondent, which means that the respondent may apply the appellant to make a security of cost. Now, the extension of time to file notice of appeal is given under Rule 66, 78 of your RFC, motions supported by affidavit. And then Rule 126 of your RFC says that the hearing. Okay, I saw a question here. Is the security for cost compulsory? Not necessarily, because as we can see from the previous slide, may order. May order means it's a discretion. Discretion means that if the judge is up to the judge choice whether want to order for security for cost. It's not really compulsory. Okay, so we come back to 126 of the RFC. The hearing is in the open court for the extension of time, whether or not the extension will be given, and the service of notice of appeal to all parties is given under Rule 48 of your RFC. Now the notice of cross appeal under Rule 47 of your RFC, you have to file it within 14 days from the date of notice of appeal being served on the respondent. Now, the memorandum of appeal and the record of appeal are under Rule 57 of RFC. It must be filed and served within 90 days of the decision is made. And then in your memorandum of appeal, you shall state concisely as what we have covered, like the distinct heads, ground of appeal, point of law or fact wrongly decided. And then, nonetheless, the record of appeal are the bundles of documents to be included as your supporting documents. Is everyone clear? Okay. Coming to the notice of appeal under Rule 47. Rule 47 under your RFC, it must be made within 30 days. Sorry, I think this one will cover already. Sorry. This one is the absence of parties. So if the appellant is absent, nonetheless, the appeal may be dismissed, but he can apply for a rehearing. And same to the respondent, the appeal may proceed if the respondent is absent at the time of appeal. This is given under Rule 26 of your RFC. Now we come to the inherent power of the federal court. Under your Rule 137 of your RFC, right, the federal court has the inherent power to prevent the miscarriage of the justice or the abuse of the process of the court. But I know this one you all have studied it in your criminal procedure code. But the thing is, logic is the same. The federal court can only review to review its own decision, not to review the other court's decision. So you see, in the case of Dr. Sri Anwar Ibrahim, our current Prime Minister, the court has invoked the inherent jurisdiction to ensure a fair administration of justice. And also in Harcharan Singh, the federal court dismissed the appeal on the ground that there is no injustice to the applicant, and the inherent jurisdiction will be invoked in a very rare and exceptional case. So is everyone clear on this? So simply means that the inherent power invoked by the court is not just because you have suffered a loss due to unfair because the unfair could be maybe the negligence of your lawyer, or maybe you have overlooked it. This is not the so-called unfair for the court to invoke the inherent power, unless it's really involved, like there must be a very serious error in the application of law. Then maybe you can appeal to the federal court, and the federal court may invoke the inherent power, so that it doesn't mean that you can get it very easily. So the powers of federal court to make the orders is allow the appeal, dismiss the appeal, override the decision, or order for a retrial. Is everyone okay? Okay, now we are coming to the past year question. This was the last year paper, and this is the first question. No, this is one of the question. I am not sure this was the compulsory one. So we see the question. Assuming that Abu commenced the action by way of writ at the High Court during the CM, the judge gave a direction and must be made within 2 months before the trial. On the first day, wished to move to the court for amend the statement of claim. The learned judge refused the request by the counsel on the ground of the CM direction. And the learned judge did not believe in Abu's testimony, found that his this and that, and then dismissed the claim. Give your opinion whether the learned judge refusal of the request of Abu counsel is appealable. How do we all think? Do you think this matter is appealable? Okay, for this matter, right, actually it is not appealable, because the thing is, it is based on a case management direction, which means that it's not a full and final judgment. So you cannot appeal. Yes, I see the question. I see the answer there. Yeah. Okay. So for everyone's knowledge, if you are going to refer to the case management, actually it's based on the Order 34. So the first thing is, now we are look at the matter, whether looking at this, whether this matter is appealable. So from the case is that this is just a case management direction. A direction uh is the court to tell you what you have to comply with. Now it seems that the parties the party did not comply, and then the court gave the direction. You see, now you want to challenge against the refusal of Abu's counsel, which means that you see, during from the first paragraph, right, give a direction, any interlocutory application must be made made 2 months before the trial. This is the direction. And then he wants to apply for an amendment, and the judge refused on the ground of CM's direction. So it is following by the case management direction. That is the reason why this is not appealable, because the case is not finalized yet. So whatever you can challenge and appeal is based on the judgment when the claim is being dismissed. Is everyone clear on this part, or do you all need any further explanation?
Sir, I have a question.
Okay.
On this question, can we rely on aturan 20 kaedah 3 of the High Court rules? Because can we look at it whether this is a first amendment and whether the pleading is closed?
Okay, I guess this is why I didn't make it through for this paper, because I also think the way like you. At the time, I was thinking, oh, since the matter is closed, okay, but the question is not focusing on whether the pleading is closed. It's now they refuse on the ground based on the CM direction. So we have to focus in other way round, this question is asking you whether the court the CM direction is appealable. You see how they fabricate the question or not? Yeah, this is
That's
the
why I'm thinking whether we can argue on this aturan 20 kaedah 3. Because you see, you are depriving him from, maybe he has reasonable facts to be amended. I'm thinking on that way, sir.
Okay, if the question now is changing, if the question now is put in this way, now being dissatisfied, what can Abu do as a recourse or a remedy? Then you can focus on the appeal. But this one, the learned judge refusal, you see, the keyword is here already. The request by Abu's counsel on the ground of CM direction. So your focus has to be CM direction, whether it is appealable. And some of this is a 3-mark question. Okay, is anyone has a needs my clarification of doubt? Okay, we come to another one. This is in 2022. The plaintiff filed a writ action in Sessions Court claiming for the breach of contract. And then the Sessions Court granted a judgment in favor of the plaintiff. Now the plaintiff being dissatisfied with the judgment in respect of the quantum of damages, filed a notice of appeal confined only to issue of damages. The defendant received the record of appeal by the plaintiff, filed the notice of cross appeal, appealing against the whole decision. Plaintiff recently discovered some documents he wants to rely on during the hearing of appeal to try persuade the High Court to increase the quantum of damages. Plaintiff now sought your advice whether he can adduce a fresh evidence during the hearing of the appeal in the High Court. I think this one is a jackpot question to me. Some more, this is a 4 marks question. You can post your answer in the group chat. Okay, I see the answers already. Okay, so since this is concerning the appeal in the High Court, right? Everything we just need to use is Order 55/7 and the case led and Marshall. Also, the principles, then we can secure this answer. We can secure the question already. It's okay. I can see most of the answers are correct already, but I don't think so. There's a leave to be obtained. Okay, then the second question is whether he has any ground to object the notice of cross appeal by the defendant. Now we come back to this question again. So you may also see at the same time you may post your answer in the group chat. I think this one is considered as a very straightforward question. Does anyone have answer? Okay, I see answer from Ting. No, actually, the answer shouldn't be this way. Because you see, the issue is the plaintiff is challenging against the decision of the High Court confined only to the issue of damages. However, the defendant's notice of cross appeal is against the whole decision of the Sessions Court. So the thing is, yes, I saw the correct answer already. In the case of Kabushiki, it's only variation of decision, not to reverse the entire decision. So by using this case, this is the ground for the defendant to object the notice of cross appeal. Okay? And now we come to see another question. In a civil suit between the P and D, the Sessions Court granted a judgment to the P in respect of only 50% of his claim, and in the respect of liability, and also reduced the claim for damages by 50%. The defendant within the time stipulated found and served the notice of appeal and confined it to damages only. Thereafter served a record appeal on the plaintiff. Upon receipt, the plaintiff served a notice of appeal against the decision of the Sessions Court in both liability as well as quantum of damages. So this is quite similar to the previous one. So your answer will be remaining the same, but just that since this is a 6 marks question, that is the so that you have to, maybe you have to elaborate a bit more lah, because the previous one is only a very short and precise answer, like you can on the notice of appeal is only for you to vary decision, not to reverse. But now this one, since everything is complex properly, now we just have to focus on how we are going to input our objection. Is that clear? Now we come, okay, Costco container. Okay, I totally understand your situation now. For this kind of situation, right, if you are not, because under panic, and I'm not sure if you are a fresher, so as a fresher, if you can remember the case and some of the principles, I can guarantee you are better than me already. Because during under panic, I couldn't even recall the case name and full factors. But I will choose maybe more than one, like 2 or 3. If there are 4, then you insert as long as more than one principle is quite good already. Okay, now we come to the final chapter of today, stay of execution. So as we have studied, a stay of execution is sought for the purpose to temporarily suspending the execution of a judgment, and also, last but not least, appeal does not operate as a stay of execution. This is a general rule. So there are different governing statutes for a stay of execution. We have studied, just now we already discussed Section 73 and Section 102 of CJA for the appeal, for the stay of execution when you are appeal from High Court to Court of Appeal to the Federal Court. And under High Court, it is given under Order 55, Rule 16 of your Rules of Court. Now, the principle to grant a stay of execution, right, is given in the case of Serangoon Garden. In the case, the court held that there must be a special circumstances for the court to grant a stay of execution. And the reason why, this is a quote, parties shall not be deprived by the fruits of litigation. So as long as you remember the case of Serangoon Garden, this is a landmark case when you are going to talk about stay of execution. This is the only case, and you can only you may also, if you can memorize the quote, parties shall not be deprived by the fruits of litigation, then you can include it as your answer. But nonetheless, the special circumstances test is the applicable test to grant the stay of execution by the court when you want to apply for stay of execution. So to further elaborate it, what amounts to special circumstances? In the case of Leong Po Shi, the things must be exceptional, uncommon, or unusual. Furthermore, in the case of Dato Sri Ling Leong Sek, nugatory principle is also another special circumstance for the court to grant stay of execution. So the nugatory principle means that a successful appeal will render nugatory if the stay of execution is not granted. However, there is also other factors like if the appellant would be irremediably injured without a stay of execution, the stay of execution will be granted. And also, if the appeal is from interlocutory application, stay of execution will be granted as well. However, merit in the appeal will not suffice the ground to grant a stay of execution. This is given in the case of MGGP Light against Tan Sri Datuk Vincent Tan. So, is everyone clear on the stay of execution? This is actually stay of execution is within the same chapter of appeal, but I purposely separate it out because at the end of the day, they are asking it separately. That's why I segregated these two things out loud. So we come to the last year paper. Advise ARBU to the relevant procedure and the applicable test to be used to challenge the finding of the High Court. This is where I got trapped lah. Because this one is, the whole issue is dealing on the stay of execution, but I got it wrong, and I put my answer as like, what are the procedures has to be complied when you are going to appeal. So you see, when you see the keyword, the rather applicable test, this is the keyword for you to answer by using state of execution, because the first and the last sentence is really, really confusing. The relevant procedure. This is where I got caught. To challenge the findings of the High Court, I kena the trap double. So the main issue is on the applicable test to be used. So this is very obvious lah. It's on testing the state of execution. So we have to use back whatever we have studied in Serangoon Garden and the factor and the applicable test, special circumstances test, Leong Po Chi, Ling Dok Seng, Ling Leong Sik, the nugatory principle, and other factors. Maybe you just need to quote another one. Because at the end of the day, because this is a 7 marks question, you have to put a contradicting one, which is the merit in appeal will not suffice the ground to grant a stay of execution. Then you can conclude your answer. That's it. Now we look at another question. The 2020 main paper of this one was also my sitting. Pending the hearing of the appeal, the defendant does not wish for the trial before High Court. Advise the defendant by reference to the decided cases and the relevant procedure. This one is quite straightforward lah. I would say it's really straightforward on testing you how to go for stay of execution, because pending hearing of appeal, so it's very straightforward and clear cut, no doubt, compared to the previous question I showed to you all. Now we come to another one, 2019 main paper. This is the first time I sit. What are the legal steps that can Ahmad take to withhold payment until appeal is being heard? This one, obviously and definitely, I'm very sure is testing you on the stay of execution already. Okay, is there any Q&A before I move to another part, which is on the past year questions in full? I wouldn't say that whether the question is very obvious lah, because we already know lah, the the question is subject to the mood of the examiner ma, so we cannot guarantee whether everything will be in a very clear cut or it could be very tricky. I couldn't assure you on this. But the thing is, you have to make sure that you are staying alert to the keywords, because it's not only for the 20 and 23 papers lah. It could be every papers also. If you're under panic, you will got trapped. So before I go to the past year questions first, right? There are certain tips I can share with you all. First thing is, please, 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 because this is very important, I have to say it three times. Avoid from the full marks question. First thing is, because we already know on 10 marks question, you have to put at least 2 to 3 points or issues that you are going to discuss, with the excluded from the intro and the conclusion. 15, at least 4 to 5. But 25, because it's a full mark question, we wouldn't know what are the examiner wants, and we wouldn't know how are they going to give you. So at least we choose those having the sub questions that it is very beneficial for every single one. Then the second thing is, make sure you have a spacing in between the lines. Like after a paragraph, you can put a space and then go for your second paragraph. But my time, I use this trick. Sentence in every single I put a space for every single line sentences because who knows, suddenly I got a sudden idea and then I want to include it, and no way and there's no place for me to include. So at least you put a space in between the lines is acceptable also, and some more your booklet is free so you can, I see some of them use 2 to 3 booklets also, but not sure that pass already or not Okay, but now we come to the November 2023. This is also my conditional sitting for last year. We come to the compulsory questions first. So before I start the questions, does anyone needs a 5 minutes break to get your coffee or go for a comfort break? Then we will come to this question. Okay, I can see one respond to yes. Okay, we will come back in 5 minutes time. Now is 03. So I will see you all in 12:08. See you all later. Okay, welcome back. Is everyone here? Okay, for everyone, since I scheduled it to 12 something, and then as of now, we are only come to the partial question. So is anyone okay if I further extend it for 1 hour plus? I will try my best whether I can do that within 1 hour plus now. Because we have to go through several questions, and because this is the first time of guiding you all the partial question, so I will be guiding you all step by step, and it could be very time consuming. Okay, now we come to the first question, which is the compulsory question. So on this day, Yusuf's father took Yusuf on a motorcycle trip from their hometown in Bentong to KL. And then Yusuf was at 16 years old on 1st June. When they arrived in KL at Jalan Tun Perak, the motorcycle collided with the PWD lorry driven by the employee, Dollah, who was from Seremban. As a result, Ahmad lost control of the motorcycle and collided with a car driven by Santos, a visitor from Philippines. Ahmad was unhurt, but Yusuf suffered injuries and took some time to recover. In November 2023, Ahmad sought your advice to file legal proceedings in court for the injuries suffered by Yusuf. You are required to advise Ahmad on as follows. The first question, who should be the parties in the proposed court proceeding? So when you see this kind of question, you have to stand by and highlight parties in the action. So from the given fact, Ahmad is unhurt, Yusuf suffered injuries and took some time to recover. So obviously, Yusuf has to be the plaintiff. So, but the point is, Yusuf was at Yusuf was 16 years old at the time. So, okay, how do we go to this question? First thing is, this is a formal question. I don't think so. We need a very lengthy elaboration on the part. The first thing is, I guess everyone would have said Yusuf has reached to a mature age at the time of November 2023. Congratulations, you are being trapped. Because the thing is, if we have gone through the top paper, the statement of claim is not from the time you file, but at the time when the incident occurs. So that we have to go back to this particular date. The reason why they put these two dates is because they want to test you whether the limitation period has lapsed or expired. But now, as we can see, the limitation for tortious action is 6 years from the date of accident. Now we see on the accident took place on December 1st. Now we want to file the action on November 2023. Limitation issue is fine. It's still within the limitation. But now we have to see who should be cited as the party. Yusuf was 60 years old at the time of accident. So pursuant to Order 76, he is a minor. And Order 76, Rule 2 says that he must be represented by a legal representative. So this is given under Rule 2. You can also include your Rule 3 because it must be done by a solicitor. Is that okay? This is the plaintiff part. This is on the plaintiff part. So that I will suggest you all, since it's a formal question, and to make your answer looks structured a bit, you may put a subheading like plaintiff, okay, plaintiff, or on the fact Yusuf was 16 years old at the time of accident, person to this and that, and then you conclude your answer over there. Now we come to the part of defendant or defendants. We see the case. Their motorcycle collided with a PWD lorry driven by a PWD employee who was from Seremban Dollar. Okay. Question now. One party or two parties? One defendant or two defendants? Okay, I see the answer is one, but sorry, there are two. Yes, Ting, you are correct. The reason why they purposely put PWD by the employee dollar is because they want to show one thing, vicarious liability. Because vicarious liability means that the employee causes a tortious action during the course of employment. That is the reason why there are two defendants in this action. One is Public Works Department, another one is dollar. Is everyone clear? Okay, so your answer is structured like this already. Plaintiff is Yusuf and represented by the litigation representative. Then your defendant, first one, dollar, and use your rules of court lah, of course, because he is an individual, he can be sued. And then Public Works Department, who is the employer, we are not sure. Okay, so this is a government body. You can sue, you can, if you are not confident with your answer like me, I would rather say put Public Work Department as an additional defendant will be sufficient enough. Because I also worry that in November, okay, I think you're quite smart, fall under limitation of 3 years. But the thing is, in November, means 1, 2, and 3. Somewhere in November is still within the limitation, right? Yeah, we are not given, this is a very tricky part. We are not given on which particular date. What if before any time or any date before the 13th November? Then we can use this assumingly, but since this is a formal question, we just put PWD in the action. Okay, we can move. Can we move to another move to question B? Okay, in which court in which city or town should the action be filed? So the first thing is you have to know this is a motor vehicle accident. Motor vehicle accident under section 65, sub 1, sub 1 of your B, there is unlimited monetary jurisdiction of your SCA lah. So obviously this has to be filed in the sessions court already. But so that this is your court, the jurisdiction of your court. Yes, it's session court pursuant to your section 65 of your SCA. But the thing is, which part of the city? So the first thing is you have to ensure that you have quoted section 2 of your third schedule of your Subcourt Act or Section 99A of your SCA, you have to determine certain factors. Cause of action arise, claim of defendant having a place of business or the residential address. So from the thing we can see cause of action is in KL. And then dollar is from Seremban. So it's satisfied within the criteria of your Section 2 of third schedules of your SCA. It can be filed either in Seremban Sessions Court or the KL Sessions Court. Is that okay? Both are? Okay, now, what is the limitation in respect of the claim suffered by Yusuf? Okay, because now it's talking about the limitation, then for things answer, you can save it on this part. Because the thing is, they are going against two persons, so the limitation period for Yusuf against PWD, who is a who is a government body, Section 2 of your PAPA, Public Authorities Protection Act, 3 years or 36 months from the date of occurrence, from the date of cause of action. And then, since this is a 7 marks question, I think you have to elaborate a bit on this part, because the 3 years is starting from this date. So you have to make sure that it is before the 30th of November 2023. However, the dollar part, dollar is Section 6 of the Limitation Act, 6 years from the date of cause of action. You just need to put as simple as that, or you can elaborate a bit further. So, and then your conclusion is quite open-end now. Because 7 marks question, right? You have to put something. Assumingly, this is a word. Assumingly, if Ahmad sought the advice after 30th of November 2023, the claim against PWD is not sustainable because limitation period has expired. You just need to put a simple line like this. Is that okay? I'm trying to help you all to simplify the questions already. Okay. Fourth one, what is the procedure to serve the writ of summon on Santos? Now we see, okay, I would like to ask an extra question. Does anyone knows what is the driving preference in the driving orientation in Philippines or not? Because from the fact, right, he is a Philippine driver. And I am not sure, did you all know that Philippines is using a left-handed driving, which means that the steering wheel is on the left-hand side. So, but nonetheless, from the fact that this is an 8-mark question, you have to put something to earn some marks lah. Order 10 Rule 1, service the rate for an individual is personal service or prepaid AR registered post. However, on the fact that Santos is a visitor from the Philippines, Order 10 Rule 1 is not applicable. But instead, Order 11 applies. And just copy the relevant parts lah. This is how you are going to address to the questions. Is everyone clear on this? Before I move to the second question. Yeah, because this is an 8-mark question, so that you have to put some effort lah to earn some credit lah from an examiner, so that you have to tell them the general rule first, and then why and how is this not applicable in this situation. Now we come to the second part. Chua made an application to Majlis Perbadanan Bukit Harimau local authority for permission to develop 2-acre land in the area. After hearing and study, he submitted. The local authority wrote to him, fix a date to deliver decision. Letter was wrongly addressed and Chua never received the letter. On the date of decision, on this particular date, when Chua was absent, local authority rejected the application and subsequently wrote to him of their decision, and letter 2 was again sent to the same wrong address. What a pity case is this. On 15 November, Chua went to the local authority office to find out the status of the application. He discovered application was dismissed on this date. Copy of the decision and the letter informing him, same handed to him. And now he is aggrieved at the decision and adversely affected by it. Advise Chua on the procedure he should adopt to challenge the decision and the legal principles involved, and whether he is entitled to make a claim for damages. Okay, so this part, since it is a 13-mark question, any thought on what is this question asking about? Okay, I've seen the answers in group chat already. Yes, I guess everyone has managed to identify the keywords. First thing is adversely affected by the decision of the local authority, and then second thing is it is a decision made by the authority. So the main thing is about judicial review. A judicial review, there must be, if you remember the case of Ahmad Jeffrey, right? There are two criteria. First thing is, it is a decision made by the local authority who was exercised the power. Second thing is, the party is adversely affected by the decision. So, from the fact of the question, right, these criteria are satisfied. So how are we going to structure our answer? The first thing is you have to put a subheading like advise Chua, and then what are the things that you are going to advise? To advise Chua, he should challenge the decision of the authority by filing an application for judicial review under Order 53. This is how are you going, this is your introduction. Second thing, how are you what is a judicial review? You have to explain it like using the case of Ahmad Jeffrey, and then what are the principles or requirements, then we can only go about the procedures like Order 53, Rule 2. You have to apply for you have to file the things, and then you have to get the leave of court, and also within how many months' time. Yeah, I think the procedures you have to serve it on the third. You have to save it at the third paragraph, because the first thing you put your introduction, then you go and describe what is a judicial review. Then you only talk about what are the procedures that you have to comply. The trial has to comply. Then you can conclude lah, based on the points given. Is everyone okay? Okay, we come to the fourth one. Okay, we go to the fourth one. All commence a civil action against Dean in the High Court, and after the pleadings were closed and come up for case management, took a view that this could be determined without necessity of witness giving evidence, as the issue, question of law, and construction of document are suitable for determination without full trial. Advice. Two modes of determination of issues: question of law and construction of document, which are available for him to choose in the Rules of Court 2012, and which mode is more suitable. I guess this one is pretty much straightforward already. Yes, this is did I have anyone answer other than? Okay. Okay, yes, correct. 14 and 14A. You since it's a 12 marks question, you cannot save for the introduction really. To advise Paul and how to as to the choices for him available one is namely 14 and 14A. So 14 is governing the determination of issue, summary judgment, the general summary judgment. And 14A is on the question of law. So does anyone still don't know what is the difference between question of law and question of fact? And you need my explanation? Okay, so since we already have two answers on hand, so we have to, after we finish for our general introduction, so we come to discuss what is Order 14 about. The general summary judgment in the plaintiff believes that the defendant has no defense and the procedures that the plaintiff has to comply. Then on the other hand, we talk about Order 14A. But when we come to the conclusion, based on the fact it is more on questions of law and construction of documents, apparently order 14A is more appropriate for Paul to dispose the matter. This is the conclusion. Your conclusion is not necessary to be lengthy. As long as the points are there, you are safe. Is that okay? Okay. We come to 3A. In a civil suit in the High Court, after pleadings closed, the defendant wants the plaintiff to provide further details of certain paragraph in the statement of claim and also wanted the plaintiff to disclose the evidence the plaintiff would adduce at the trial, advise defendant on the procedures to be adopted and the legal principles which are applicable. Any thought from the group chat? Okay. Yes. Yes. Further and better particular. So since this is a 10-mark question, so your introduction is the defendant is advised to apply for further and better particular from the plaintiff pursuant to Order 18 Rule 12 of your Rules of Courts. Then you can in your second paragraph, you have to explain a bit lah. What is a further and better particular means? Which means that using the case of Lim Ki Tia, you can only solve for the matter arising out from the fact itself, from the pleadings itself lah, because it's not fully disclosed yet ma. So you have to explain a bit on the case of Lim Ki Tia. Then your application to the court is given under Order 32 Rule 1. Notice of application in Form 57 supported by an affidavit. This is not the end of your answer. Because however, if because the court the opponent party may object on the following grounds. First thing, they are not obliged to do so. You see the question it talks about the evidence. So come back to what we have studied in our Order 18 it is not necessarily by putting the evidence in the pleadings, because what we have studied in the pleading is that plead the fact, not law. Plead the material fact, not evidence. So it's not necessarily for the defendant not necessarily for the plaintiff to disclose the evidence. Is that okay? This is the extra point you can include at your answer lah. But the thing is, nonetheless, you still have to write out, you have to structure your everything like this. First thing is your introduction, how to advise the party. Second thing is what is the definition for this particular thing? Like we already talked about the further and better particular mark. First step, we advise the party. Second step, we explain what is further and better particular. Then we only go about the procedures. But as a conclusion, you may add this as your extra point where the plaintiff may not need to include the evidence pursuant to Order 18 Rule 7 as what Ting has put in the group chat. Thank you, Ting. Is everyone okay on this part? Okay, we come to the B. The plaintiff filed a civil suit against 3 defendants. Against the first defendant, claim of possession of immovable property, declaration, and general damages. Second defendant, possession of immovable property and liquidated. And third defendant, claim for general damages. Okay, after writ and summon served to 3 defendants, they fail to file their appearance within the time limited to enter the appearance. What is the cause of action? So on the fact that this is a 12 marks question, may I know from everyone what are the points that you all might include in your answer other than the JIDA? Okay, as I can see, there are some answers here. Execute the JIDA, of course. There's a main part of your question, but the first thing is you also have to include certain thing. Yes, limitation of time. First thing is you have to tell to the examiner, although the examiner didn't ask, what is the time frame for the defendants to enter into appearance? Order 12, Rule 4. Within 14 days, the defendant is required to enter into appearance. From the fact that the 3 defendants fail to file their appearance within the time limited, then the plaintiff can enter a JID, because I always use it as JID lah. Maybe you all use it as JID. The plaintiff is advised to enter into a judgment in default against the 3 defendants as follows. This is your introduction. Then you can start your subheading with the first defendant. From the first defendant, claim for possession of immovable property, declaration, and general damages. Now we look into Order 13. This is more than one claim. So it is a mixed claim under Order 13, Rule 5. So against the first defendant and the second defendant, these are Order 13, Rule 5 because it's more than one claim as well. That's what the wordings are. With two or more than the claims, yes. So Order 13, Rule 5 is satisfied. However, when we come to the third defendant, it's claim for general damages only. So it's unliquidated. So it falls within Order 13, Rule 2. Then your answer is there already. Is everyone okay? Well, another jackpot question again. How is the service of writ effected on a company under Rules of Court 2012? They never asked you about. That means from this three marks question, they are not asking you about the Companies Act. It's purely based on rules of court. So it's very straightforward. Service of Order 62, Rule 4. And you just need to copy the following methods: leaving a copy at the registered office, sending a copy by registered post, handling of copy, this and that. Yeah, this is how you answer the 3 marks question. Okay? Okay, now we come to the next question. ABC obtained a judgment for specific performance for 5 shophouse against XYZ in the High Court. After judgment was drawn up, ABC discovered following discrepancies. First thing, penal endorsement. And then second thing is the title particulars of one shophouse were incomplete, which might affect the intended registration of title in land office, and the judgment did not include the 5th shophouse, and the search in the court file indicated that the court did not grant specific performance. Now the ABC wants to rectify the judgment. And to me, right, this amendment is amendment of the judgment. So purely you have to rely on Order 20, Rule 11, because it is all about amendment of judgment. So to suggest you all, since the fact has already mentioned about the judgment, you have to write it out. How and when a judgment is perfected. This is the first part of your answer. Then the second part is the effect of a judgment is binding the party, if you already know. But how are you going to amend the judgment? That is how your Order 20 Rule 11 comes in. Third thing, what is the factor that allows you to amend a judgment? It must be a slip rule, correct? So as long as these 4 examples are there already, you can have your own, you will have your own conclusion already. Is that okay? But there is a tricky part on here. I don't think so. The following two. This one is under the slip rule, but these two, I don't think so, is under the slip rule. So that maybe in your conclusion, you may add on a little bit to discuss on this since 13 marks is given. Okay, we come to sub-question B. Tan and Wong were equal partners in AAA, a registered business. After a fire destroyed, they decided to cease the business. They filed a claim with super insurance. With respect to the fire insurance, subsequently, Wong passed away and his wife, May, was appointed as the administratrix. Super insurance approved the fire insurance compensation. Tan made a claim for the entire compensation. May also made a claim for the entire compensation. Both Tan and May have appointed solicitors who have made separate demand to super insurance to pay entire compensation. What is it all about? All right, interpreter. So if you are go, so if the so how to identify the keywords? I think the key points start from here already. May sorry. When the insurance sum approved, Tan made a claim for the entire compensation. May also has made a claim for the entire compensation. So that both Tan and May appointed solicitor to demand for the compensation in full. So this is very clear cut that it is all about the interpreter. So that in your introduction, right, to advise super insurance, that advise to apply to the court for an interpreter action, interpreter proceeding. And from the fact, the more appropriate one will be the stakeholder interpreter. Then you can put your case, the what case? Yeah, the Tuan Teh Kim Teh, this case, and then and then you also can generally and briefly explain what is the case all about. But when it comes to the procedure, then you have to copy Order 17 Rule 3 precisely on the 17 Rule 3. Let me find it. First thing is your mode of application is by originating summon. Unless this is a pending action, is notice of application supported by affidavit. And then what you have to do under Order 17 Rule 3, you have to summarize it, and then service of this under Order 17 Rule 4 and 5 powers of the court when hearing the action. Then your answer is there already. Is that okay? Okay, now we come to question number 5. In an application for summary judgment, and then plaintiff has given notice to the defendant of his intention to object admissibility of the affidavit in reply for the following grounds. So it's very clear cut that everything is based on affidavit under 41. First thing, hearsay evidence. allowed or not? Okay. Uh, Shamala Devi, I think you have to refer to the case of Bottenheim because the case says that the court held that hearsay evidence is allowed as long as you're substantiated with the grounds and source. Now the second one is, this one refer to the plaintiff as fraud and unethical person. This is very clear cut. Okay, I will type the case out. As we can see, he is accusing the plaintiff as a fraud and unethical person. So it is the scandalous matter as per Order 41 Rule 6. And then the court may order to strike out the affidavit under this situation. And the case is Ri Ong Eng Guan. I will type the case in the chat box now. And the third part is one of the exhibit annexed did not contain the certificate of the commissioner for oath. What about this one? Okay, I think everyone has to refer to these rules already. 41 Rule 11. Document shall be exhibited with a copy and the certificate and identified by a certificate. So obviously, this one was not complied because he failed to annex it, identify it with a certificate of the commissioner for oath. So basically, when we file when we file the affidavit, right, at the end of the page, at the end of the pages, each of the document will be accompanied by a certificate affirmed by the commissioner for oath and marked as different exhibit. Let's say you have 5 exhibits. So the certificate will indicate this is first one, then second, third one, fourth one, and fifth one, etc., etc. So that every single evidence has to be exhibited separately. So from the fact here, Order 14 Rule 11 is not complied. Is everyone clear? Okay, now we come to the fourth one. Address of the defendant in the affidavit in reply was erroneous. So I know this is quite new. Never mind, we come to this one. Alteration. Because this one you are going to amend the affidavit so that it has to come with a jurat. For everyone knowledge for everyone's information who wants to know what is a jurat, I have put it in the previous slide so that if you all need, you can refer to the recording or the group chat. I've sent it in the group. In the slide, I've shown an example of how does a jurat looks like. But although the defendant can use Order 41 Rule 7 to amend the affidavit, it is advisable that he file a fresh affidavit by including everything in the correct with the correct information. Is that okay for everyone? So to summarize everything, for this one, it's quite simple only because it is 4 points divided. So you can use a subheading. Firstly is the Bottenham case, hearsay evidence. Second subheading is on the fraud and unethical person, Order 41 Rule 6 and Wee Ong and Guan. Third one is 41 Rule 11. Then the fourth one is Order 41 Rule 7. These are not the problem, but the problem arises on your conclusion because we already know that three things he can the objection is sustainable for the first three, but the later one, that is the reason why when you are going to write your conclusion, you have to write in like this way. The defendant may be successfully overcome the first three objections, but the fourth one, because the plaintiff can file a further jurat, can file a fresh affidavit, or file a jurat for the alteration purpose under 41 Rule 7. Is that okay? Okay, we come to the sub B. C, employ the contractor and architect for construction for him for construction in Portixon. Almost immediately, bungalow completed, partially collapsed. C, determined to find the cause of collapse and file legal action. Both contractor and architect denied the liability. Contractor argued he relied wholly on the architect drawing. Now ask the architect to provide him the drawings, but architect refused to do so, wants to have the access to the drawings so that he will know who to sue. Very straightforward, this question. It's about discovery only. Anyone can I have your thought? Yes, it is Order 24. But whether it's Rule 7 or 7A, okay, I've seen the correct answer already. It's 7A. So how does the different what is the difference between the 7 and 7A? So you see, Rule 7 is order for discovery of particular documents at any time on the application on the party. And now 7A is against other person. We come back to the question. C wants to have the access to the drawing so that he will know who to sue, which means that no action is commenced. And then this is a pre-trial action because he wants to obtain the document from a stranger. So very, very clear that this is under 7A. Since this is a 9-mark question, your introduction will be C is advised to apply for discovery action under Order 24 Rule 7A and use the general rule. Discovery against stranger is not allowed in the case of Norwich Pharmaca. The court held that discovery against the stranger is not allowed unless you want to identify who is the stranger. Want to identify who is the defendant. Therefore, you have to use the case Norwich Pharmaca as your introduction, and then the relevant procedures under Order 24, Rule 7A accordingly up to the end. But nonetheless, you also have to include this one. The court will only be given if it is necessary to do so. Is that okay? Okay, this one. When does a court make an order for costs thrown away? This one is very straightforward. Just find your order 59 when it is all about cost. Copy the entire thing. That is the thing. For your 4 marks question, order 41, order 59, rule 1, and then you copy the explanation or the definition from here. You can move on to the next question already. Now we come to 6A. Bala filed a writ of summons against 4 defendants, wants to amend the writ of summons and statement of claim in the following manner. First one, amendment of the first one, incorrectly stated, served, and he filed the affidavit, filed the appearance, wants to amend the writ of summons and correct the name. Okay, second defendant, he has filed his defense, want to amend against defendant by including additional prayer against him. Third one, he wants to amend in the capacity. Okay, I think it's better that we go to one by one. So for the first one, he wants to amend the writ of summons to correct the name of the defendant, whether it's allowed to do so. Yes, so according to Order 20, Rule 5, Sub 3, what's Rule 1? Well, Cindy, I think your answer is more on point. Thank you, Cindy. Because we look at her answer. But since on the point that the pleadings are closed, so you have to use this one, Order 20, Rule 5, Sub 2. And then leave of course is required to amend the pleadings. So from this one is to amend the name of the defendant. Yes, it's allowed under Rule 5, Sub Rule 3. Okay, what about the second one? Including an additional prayer against him. Okay, for this question, right, I will suggest you all to use another time, again, for the magic word, assumingly, because he wants to add additional prayer against him. So amendment may be allowed, assuming that the prayer is arising out from the same fact, from the same action, then it may be allowed. This is given under your 20 Rule 5 sub 5 may be allowed if the court, if same facts lah, and the case is Hock Hua Bank. Then the third one, he wants to amend the capacity of the third defendant. Can or not? Okay, I see the moment of truth already, but we have to go through it. Amendment to alter the capacity in which a party sues. Okay, I think for anyone use 20 Rule 5 sub 4 and says yes, you may be penalized. Because who is Bala? Bala is the plaintiff. He wants to amend the capacity of the defendant. Pursuant to Order 20 Rule 5 and sub 4, you see, amendment to alter the capacity in which a party sues, which means that the plaintiff is only allowed to alter the capacity of the plaintiffs. If there's more than one plaintiff, either plaintiff can amend themselves, not to amend the others. That is why this is how the Order 20 Rule 5 sub 4 applies. You can only apply to amend for your side, not the other side. Is that okay? Okay, the fifth one, he wants to add a proposed fifth defendant, can or not? Okay, for your information, on the fact, amendment, you see, Rule 5, second one is with the leave. Third one is to amend name of party. Fourth one is to amend the own capacity. And then fifth one is to add or remove a cause of action. Nothing to Order 20 is related to adding a party, so that this one has to be done by way of Order 15 Rule 6. So to conclude the answer, right? Yes, Bala may apply to amend first and the second defendant, but on the other hand, third one is unable to amend, and fourth one, it shouldn't be done by way of amendment, but adding a party under Order 15 Rule 6. Is that clear? Okay, we come to the B. Tanom, a Thai national, Su Chong in KL High Court for damages arising from breach of contract. He does not have a permanent address, spent 4 months in Malaysia, and stays in hotel during this time. He filed a suit against Chong 2 years ago, and the trial date fixed on January 2024. And Chong recently filed application for security for costs against Tanom, that he is ordinarily out of the jurisdiction and will be unable to pay costs, and then admitted to you that he is facing financial problem due to Chong's wrongful breach of contract. Advise Tanom whether he can successfully dispute Chong's application for security for costs. Okay. Can I have your answer in the group chat? Because I think this one we just covered it quite recently. It's purely based on the security for cost. And this is a 9-mark question, so that the logic is there. You must put at least 2 to 3 points. So first thing is, you have to define what is a security for cost, Order 23 Rule 1, and what are the requirements for the security for cost applied by the defendant. First thing is, the plaintiff is residing out of the jurisdiction. See, Tanom is a Thai national. First one, satisfied. Secondly, he whether he's suing for someone's benefit, we are not sure. Then the third one is change his address during the course of proceeding. Never mind, find this one first. Okay. Is ordinarily resident out of the jurisdiction, be satisfied. Then whether he is a nominal plaintiff, we are not sure. And then the plaintiff address is not stated in the writ or OS. This is what we can share because he is staying in the hotel during the time he is in Malaysia. This one is satisfied already. So as long as there are more than one criteria satisfied, Chong may apply for the security for cost under Order 23. And then we can copy we can use we can copy the procedures, like what can Chong do, filing notice of application supported by affidavit under Order 32 Rule 1. This is the second part of your question answer. Third one is factors considered by the court. So in the case of Sir Lindsay Parkinson, there are few principles governing the factors considered by the court. First thing is whether there is any oppressing conduct Secondly, whether the application is bona fide. Third thing is whether the success by the plaintiff is reasonable. So from the fact, we are not sure whether it is done by oppressing, but the thing we can for sure is bona fide, because Chong is in the view that he may not be able to pay the cost. So we can use this, we can copy whatever, we can use whatever factors that we remember in the case of Sir Lindsay Parkinson. Then the fourth one is, how are you going to object? Because we are advising Tanom. In the case of Tanom, in the case of Dato' Le Cheng Chai, as I have discovered earlier, as I have discussed earlier, In the case of Dato Le Cheng Chai, the court held that you cannot simply apply for security for cost merely because the plaintiff is a foreigner if there is no other way to show that you cannot be compensated. This is the first argument. Second argument is Adarsh Pandit. Although the plaintiff is having a little sum of money doesn't mean that security for cost will be given. So you may use this two or either one of the case to support your objection. Because we are advising Tanong now. Is that okay? So, okay. So conclusion because we already explained what is security for cost and the procedure and also the factors considered by the court. Now conclusion is to advise Tanong whether he can dispute Chong's application. He may rely on the decision in the case of Le Cheng Chai, and then also another case which is Adarsh Pandit. You have to briefly explain what is the case fact, and then this is the objections that Tanong can rely upon. Is that clear? Okay. When does a court make an order in a cause of matter begun by originating summon to continue as if it had begun by writ? And what discretions does the court give in such event? I think this one is also very, very easy because this is the first chapter that we discovered. It's purely under Order 28 Rule 8, which is the conversion of an action from OS to a writ action. So you can summarize everything under Order 28 Rule 8 sub 1 and then plus this case, Ting Ling Q. So with these two answers, your 4 marks is secure. Okay, now we come to the last question. During the course of a trial in the High Court, the plaintiff counsel informed the judge that the plaintiff last witness, who was crucial to the plaintiff case, unable to attend, and the plaintiff counsel request for postponement. Request was disallowed, and the plaintiff counsel was ordered to close the case. Defendant counsel unable to open the case as none of his witnesses, including defendant, were present to the court in the court. Now the defendant counsel request for postponement was likewise refused by the court. It is apparent that plaintiff has failed to establish the case. In the absence of the last witness, advise the defendant how should he proceed under the circumstance with reference to relevant case laws. Okay. Does anyone know what is this question asking about? All right, it's a submission of no case to answer because the keyword is here. It is apparent that P has failed to establish the case. So, as your introduction, you have to advise the defendant's counsel. He is advised to make a submission of no case to answer. Then you generally describe what is a submission of no case to answer. Like your case, the plaintiff has failed to establish the case or the evidence is not reliable. Then Laurie and Raglan call. If the defendant has made a submission, he is not allowed to enter into defense again. However, in the case of Story and Story, if the defendant is not given a choice to make a submission of no case to answer, then he is allowed to make a defense. When you describe everything out, then this is your answer already. Because for submission of no case to answer, is not available in the rules of court because this is a English practice, which means that you are showing hand to the opponent that you have no case. Now, I want this case concluded and then you did not establish your case. That's all. That is the reason why when the defendant has filed a submission of no case to answer, he is not allowed to make a defense again because the reason is that the defendant is not allowed by the second bite of the same cherry, which means that you cannot, now I already made a submission of no case that plaintiff did not establish the case, but subsequently I am going to make a defense because suddenly I found out the plaintiff has made out his case. So that means it's double jeopardizing and also prejudice the right of the plaintiff. Is everyone clear? Okay, we come to the B. Baka obtained monetary judgment against D in the Sessions Court on this date. Dow went into hiding after that was only traced by Baka sometime in November 2023. Dawood owns and manages an outlet selling handphone and computer. Baka immediately sought your advice to enforce the judgment against Dawood. Advise Baka on the procedural steps and the appropriate mode of execution he should be adopted against Dawood. Any answer? Okay, if your answer is only 47, right? I think your answer is not that complete. Because the first thing, why they have to purposely tell you this date? Because they want to let you know what is a limitation. So your introduction is you have to tell to the examiner whether it's still within the limitation period. So according to Section 6 sub 3 of the Limitation Act, enforcement of judgment is 12 years from the date of judgment. So from this date, right, you are still within the limitation, but because today is November 2023, 6 years has been lapsed. So under your Order 46 Rule 2, leave of court is required, and you have to tell to the examiner precisely on how to apply for the leave of court is given under Order 46 and Rule 3. You have to copy whatever available in your Order 46 Rule 3, such as your ex parte notice of application supported by affidavit and the contents has to comply with your Rule 3 sub 2 explaining why you found this out, why you execute your judgment quite late, this and that, whatnot. Because at the end of the day, it's the court's discretion whether or not to grant. That is the reason why you have to include a strong and valid reason to tell the court why you enforce the judgment quite late. Then, as to the appropriate mode of execution, from the fact that he managed an outlet selling handphone and computer, then yes, correctly, your 47 rate of seizure and sale. 45 rate of seizure and sale, and also your 46, 47, because he includes the immovable property, and also this one is the movable property, and this one is immovable property. So that you have to copy for 47, Rule 6, everything. Is that okay? Now we come to the last question. This one I'm pretty sure that I've included in the last topic, in the last session or previous session, because it's about attaching the pension. And also the pensions account is with the Bank Simpanan Nasional. Shamala, you want me to repeat how to structure on the Part B, right? Okay, so the first thing, how do you start with your answer is that for more than 10 marks question, for more than 5 marks questions, I would say, more than 5 mark question, you must give a brief introduction. Like for this one, limitation period is the first thing. To advise Bakar, first thing we must ensure that he enforced the judgment within the limitation period. So under Section 6 sub 3 of the Limitation Act, enforcement of judgment is given 12 years of limitation period. So he is still within the limitation period. However, from the fact that it has been lapsed for 6 years, according to the case of Dr. Shamsul Bahar, he is required to apply for the leave of court to execute the judgment, and then he is not entitled for the interest. Then you only come to your appropriate mode of executions, like your rate of seizure and sale, prohibitory, and that's all for the 12 marks. Is that okay? Okay, now the last part, I'm pretty sure that I have explained it in the last session that first thing, Pensions Act already stated that prohibition from attaching the pensions, and then the Bank Simpanan Malaysia National Act already says that you cannot attach someone's money in the bank account under BSN without a consent. That is the whole answer. That is the whole answer for this question. Is anyone having questions to ask? Okay, I think that's all for me today. So I will stop the recording first, yeah.